I'm taking my time to grab a bite to eat.
Can't hear you. Can you hear me, Keith?
Yes, brother.
I can't hear you. Your mic on?
My mic is on.
Your mic off?
Yeah, his
I can't hear you.
mic's on.
I got another thing. So what I want to get with you this week, instead of us having to keep going through all this Zoom stuff, I just pay for a Zoom in your name. And we just pay, I think it's like $100 and some dollars, so that we don't have to keep doing this.
I'd be glad to do that, but
I don't know why I can't hear you. I can't hear
can
you.
anybody else hear me?
I don't know why. Let me go out. and come
Yeah, I
back.
can hear you.
I can hear you just fine, Keith.
I can hear him too. It must be him. You know how you call in over the audio? Like maybe he hasn't done that yet.
Is that better?
Can you hear? Let me see if I can. Trying to see if I can. If I can. So this is what I was saying, right? So one of the things I had did all these contracts. I had like a manufacturer agreement and a franchise agreement, a distribution agreement, and then I had in the manufacturer agreement. The purpose of the manufacturer is that I manufacture the assets, which was the bonds, and the bonds were manufactured, and that they could be redeemed in gold or converted over into an asset, right? For any contribution in which can then be redeemable in commercial paper or in gold. That was some of the language that I was using.
Right. And that's what the Senate document number 43 talks about, it contracts payable in gold. That's why I say when you do that, you have to make sure it's very important that you learn the language of gold weights and measures.
Right.
Because it is available. We can do that and they can accept those, but they have to find somebody else on the other end to do that gold exchange through the note.
Okay. So I just had a bunch of language that some of the stuff that I was using that I understood, and I was trying to make sure that I aligned, because everything that you're saying, I'm relating. I just need the, like I tell people, the devil is in the detail, the specifics.
And
that have to do.
the way you're doing it sounds okay and everything, and it's very feasible. But again, I strongly urge people, instead of getting into that system and investing in that system, I suggest getting out. And then when you do those donations, you know, that banking transaction, you go down to your local pawn shops and you buy up all the gold and silver.
That's so so what I was doing is the private banker acceptance agreements in the form of a manual, because like I was looking at how everything is from being a consumer versus being a manufacturer. A manufacturer puts stuff, replenish the earth, and a consumer takes from the earth. So what I was doing is as I was relating this information, I was saying, okay, this is what I have to do. This is the language. Like you said, give them something, give them half. Like everything you're saying, I just need cause once I get the stuff like once I get it, I got it, and I just need the little because drafting the contracts is that's not the big thing for me. It's understanding how to orchestrate everything with the proper people so that you can go in there and get the results you're looking for.
Exactly. And that's why I say you're not going to be able to go into a bank and talk to a regular banker or teller about this stuff. They're not going to know. You have to know the specific people you need to contact. And that's why I say, in that banker's acceptance thing, it tells us that we should be have a long-standing relationship with the one that we're going to be working with. My companion has a bank account that she's had established for a number of years. She was a public educator, and the banker happens to be a medallion stamp banker. Who better could it be? Long-standing relationship, and we've already gone in and talked to her face to face about our intent, and that is just simply to remove everything from probate to establish her private estate. Oh, okay. Well, you need to do this, this, and this. So they will help you. It's just that they can't give you legal advice. They can help you step by step, tell you what your next step is. If you present something that's not right, they can say, well, let me check with the legal department, see what they say. And then they're always going to give you something that, well, it's not worded right. And, we can't give you legal advice, but, it's just wrong kind of verbiage. They're going to give you something to go on. So you can always just, it's a matter of correcting the record. That's all we're trying to do.
But even with the verbiage, right, we still in our truth. Like some of the things that I learned, there's some blurred lines in like that so what I like to use the term is that this document has been transliterated been transliterated so it can be translated into English so that the parties in which I'm doing business with can um can read and entertain this document. So I got particular verbiage that I use from transliteration to translation so that's all in my documents, like my hereditaments, all of this stuff, so people can understand, like, look, this is not originally written in English because English, like you said, is a massive language. And they control all that legalese, all their terminology. So if they accept it, they got to accept it as face value based upon my verbiage, not just their legal verbiage, right? So that now we could do business because, like I try to get people to understand, there's three components. There's clarity, there's clarification, verification, and then there
Justification.
is
Yep.
not just justification is the last one, but it's certification. It has to be certified.
Oh, yeah.
And that's
that's one of my biggest things. If it's not certified, then it ain't good at all. It's got to be certified in order for it to work properly.
Yeah. So a lot of people miss that. So with the certification process is authentication is that you need witnesses. So what I don't tend to use affidavits at all. I just use notary acknowledgments or attestations. So what I do with my documents, I get all my documents, my contracts together, and then I get the notary to attest to everything that happened, right? And then I get it authenticated, showing that she was a true notary, so it can have the full faith and credit, because the contract itself is separate from that. The notary just attesting as a witness. So I tend not to use affidavits anymore. I don't do that. So
most people know that as notary presentment.
right. And so I got away from using documents. So one of the things I always use when I'm referring to someone, if it's any errors, omissions, or defects, right? They have a time computation to correct it and send it back. Failure to do so, they waive any defense for any and all reasons and purposes that they permanently waive that defense. So if they don't send it back to me in a proper time manner, once they got the document or the, like you said, the banker's acceptance, they forever waive and now they can't come back and
And that's
argue.
why I say give them 125. If you want 250, give them 125. That way they have no reason, nor do they actually have an ability to overwrite what you overwrite as a correction. Like you said, they got to come back with either the acceptance or the rejection, and they can't come back with a rejection, so it has to be accepted. That's what keeps them in honor.
My other question is, who do we, now I got that out the way, who is the proper parties? Because this is another thing that I learned. If you don't address the proper parties, even if you say notice to agent is notice to principal, you still have to CC it to the proper authorities so that they can deal with it.
Right.
So one of the things that they would do, they have what they call a plausible deniability. When you don't send it to the proper authorities, they can say, well, look, you sent it to a person who didn't have the jurisdiction to deal with this. So they didn't know what to do with it. So they just let it sit there. And now you're expecting a remedy, and you can't get no remedy because you didn't send it to the proper authority to deal with that, or you didn't even address them to ask them to do it or forward it to, or you didn't even specify in the language in the letter, please refer this letter. And this is why I say the Freedom of Information Act or the Open Information Act is very important when dealing with government, or if you're dealing with a private person, you still got to communicate with them and say, look, if you're not the proper person, please direct me to the proper channel so that I can send this to the proper authorities to deal with this. Please prefer me to giving me the address and the contact information of that party.
Yeah, and this is important to realize. Just like I said, it's just like a developing country or a bankruptcy. What they do is they do a search to find out in a bankruptcy who all the creditors are. And that's what you're going to have to do yourself. You're going to have to do a search to find out who all you need to notice. But that search shouldn't be hard if you deal with that banker right away. Find a banker right away. They're going to know enough about this to find out how to seek out all of the creditors listed under that credit score and everything. And it's just a matter, like I said, everybody's got a different situation. Mine right now, I'm dealing with my companion, trying to remove everything from probate and establish her private estate because she's now retired. And so there shouldn't be any question. She's no longer required nor even allowed to transfer U.S. obligations. Therefore, it is, we need a transition period to establish her assets, her private estate. You can't, and it's a fundamental function of human welfare in their system to provide for the housing and welfare of people that are dependent upon that system. That system, whether it be commercial paper or credit transaction, is the same thing. And they can do the credit transaction for an individual just like they can do the credit transaction for an entire nation. It's all the same operation. What else, guys? You guys realize, just like I said, that banker's acceptance is synonymous with so many different things. And what we're doing is using it just like it states its purpose, as a trade transaction. It operates as a trade transaction. And that's what we're doing. We're going to trade the probate commercial paper system for the electronic credit transition. Everything's going to be removed and it's going to be electronically protected by that one account.
So we have to find, so what we have to do is establish a relationship with a medallion stamp banker in order to do this. What about Fidelity? What about those institutions?
Yep, you can do it with Fidelity. I believe you can even do it through the post office, but I'm not quite so sure. So I'm not working with the post office in that capacity. I will find that out later. But so for right now, I'm just using the local banker that, like I said, we already have an established relationship with. We don't have an established relationship with the postmaster, so we're not even going to attempt that. That's just too much trying to educate them in that capacity. But I'm sure they're qualified for the same thing because the banker is internal. And like I said, they're the ones that actually regulate the judicial system.
So let's say this. Let's say we can't get nobody to cooperate. How will we go about exercising this process?
That's where the international level comes in with the Uniform Customs Code, the Constitution with the UPU, the Treaty of Berne and the Vienna Conventions. There's a Director General of the International Bureau, and this is all done through the Swiss Confederation. All of the members of the UN agree to the Constitution of the Universal Postal Union, the UCC, the Berne and Treaty of Berne and the Vienna Conventions as part of that union. And that's so that they can trade their commercial fiat papers. That's all it is. And so we're just going to go to the Director General and the Federal Chancellor of the Swiss Confederation. Hey, listen, these guys are violating these treaties.
So who is that? The General Chancellor?
The Federal Chancellor of the Swiss Confederation. Let me pull it up.
Federal, well,
And there's a link in the chat section. This is the government that the UN goes through in order for all of their peace treaties, the Vienna Convention, the Constitution for the UPU, and all that other stuff. Got a brief guide in here. But the Federal Chancellery is right here. You got the Federal Chancellor is Walter Thurnherr. Vice Chancellor is Andre Simonazzi, and the Vice Chancellor Victor Rossi. These are the Federal Chancellery Acts on the basis of the Government and Administration Organization Act, among other regulations. And this is all spoken of in the documentation of the UN and everything throughout the peace treaties, Vienna conventions. You'll see all this kind of language. And we're talking about chancellery, equity. Court of Chancery is the same thing as a court of equity. This is equity on the international level.
so everybody keep talking about the Chancellor Court. And I'm like, United States, they got rid of the Chancellor Court. So I got a lot of people saying, well, the Chancellor Court is this. And I'm like, I don't think so.
The Chancellor Court, it runs concurrent. It's a concurrent jurisdiction in the United States, but it's ran over the international. I mean, you could just look up, the family courts are all, Chancellery deals with real property. So that's what probate is. And it's concurrent, it's just kind of hidden. Someone needs to know how to evoke it by the way that they conduct themselves. And you can look up in Tennessee, after the Tennessee Valley Authority Act, they actually have a chancery court there, and you can look up their different forms that they offer to the public, and it'll show you which ones are equitable.
I was looking up Ohio, and Ohio, they don't have because the probate court from the history, they were saying that they did away with the chancery court in Ohio and really
Well,
redid it with the probate.
Ohio's, being that I'm from there, it's a very strange situation because after the Northwest Ordinance, everything went sideways. And, Ohio technically isn't even a state. They don't even have like all the things that were needed to be admitted into the union. They didn't have like a real constitution. So, most of what we're dealing with are territories, providences, depending on which particular church is describing it.
Right. So as we dealing with the providence, so what I'm trying to relate, because there are how many 11 district courts, and all of these districts are also their own states. They're
Yeah,
also,
have you ever heard of the Mother Court in New York? The one district court?
oh, oh,
Yeah, that's pretty interesting. Yep.
other court in New York. Okay. So where do we? So we just invoke the chancery court by just putting it in the through the probate, because there is no rules.
Yep. And that's what everybody talks about with the special appearance and stuff. You can invoke a court of equity simply by standing there and saying, I'm an idiot. You can invoke it by saying the Lord's Prayer. There are a lot of different ways you can invoke equity court. You just have to, again, be able to determine the best way for you according to your circumstances. Us, we're doing it through the bank. We're going to invoke it through that commercial paper.
So now under the civil rules, they have what they call, like I try to tell people, if you're gonna enter the court, it better be under a special type of circumstances, whatever, because they got different provisions for special groups or special individuals as it relates to subject matter jurisdiction. So you make a special appearance, you give them a special, like a notice. Um, you're always supposed to give notice. Then you can either you come under a special appearance. So do you? Because I went through all, like, I'm very familiar with the probate court. I was going through all of that, and the reason why I didn't do stuff, I was helping people at first get their, like, I'm a Moor, so we were going through getting their nationality. So, but it was something that I was looking at like, I don't want to do it that way in some aspects through the probate, because I learned that, like you said, the like I was telling people, the public school is a trust, the public libraries are trust, all your public university or major universities are trust. So I said you can put documents into the school records, in your children's school records, because a lot of people was talking about they're getting their kids took them from them. And I was like, well, you got to start somewhere. And I said, you can put it into their school records about the power of attorneys and all of that. You can limit or revoke or do anything, and you can put it into their school records. And then they'll know how to deal with your children.
Yeah. Yeah. And that's a very important point. People need to realize that when they're signing up their children for school and everything, when you take your children to a doctor, there's always an assignment of powers of attorney. Always. Something hidden in the background that says they have to have the authority to do this, and it has to be given to them. That's the point, that you have to give consent. If you don't give consent, then they can't do anything. So when you're doing those documentations, make sure you give them the right consent to do the right things.
Exactly. So
I do not give consent to have third-party involvement of CPS to come in and look at a bruise on my child's leg and have them go crying, concerned that my child is being abused. It's not for them to discern that. If I thought my child was being abused, I wouldn't be sending them to school, because that's where they get abused.
So That's one of the things that people have to look at with their stuff with their children being taken. Another thing I try to tell people is with the birth, when your children are born, you have to have powers of attorneys and all of that stuff, explaining, giving instructions. Anytime, see, people think being incapacitated mean that you have to be in a coma or you hurt. No, incapacitated means that you're ignorant.
Yep.
Also,
Legally incapacitated. That's why I said earlier, idiot. I'm legally incapacitated. I don't know your legal terms here.
exactly. So a lot of
Or how
times,
about the banking part? Not knowing how to do the banking part is also a form of not being competent in the age of discretion. You know,
Yep.
that's the real issue, is
Yeah.
not learning this part about banking, because even the term child and parent is business. It has nothing to do with the boy and the girl and the heir. It's literally banking, and that's the setting the two apart. You know, and that's,
Think
from
about
my
this.
own trials and tribulations in this life, which I give thanks for, is recognizing the
that's why they call a parent company.
Yep.
It's a parent company, and you got to understand the laws of agency, right? They have a thing
Yeah.
called laws of agency. So
And notice the very first code that they use says words denoting numbers, gender, and so forth. And so in their world of notes, all they're doing is denoting. Sounds kind of odd to me.
right, that's why I talk about the hereditament with birthrights, because there's a difference between civil rights and heirship rights.
Yeah.
It relates to claim of rights.
Yeah, you can be an
So,
heir or you can be a beneficiary. An
exactly.
heir is automatic and doesn't need the description of a beneficiary. Beneficiary can be a beneficiary and not an heir.
Well, and
Exactly.
that could be the juridic person can be a beneficiary,
Yep.
and the belly button man and woman, as Brian calls it, is the heir.
Yep.
So, like,
And
what's
that's what we're talking about. Yeah.
yeah, and that's what's interesting because, unlike what you're doing, which I'm also following as being the man and woman, my juridic person, I'm trying to level that one up. I'm trying to take that one up, which a lot of people are trying to separate and get away from. But I'm like, hey, I got this person that could get all these numbers and do all these things that, I think could be beneficial. But for me, talking about the sons, my issue with sons, I mean, part of that, there's lots of remedies and cures to fix it. But depending on who one is up against, like me, I have to be fully cloaked in the whole armor because of the adversary that I'm addressing. And that means truly 100% comprehending particularly the commerce part, because, for the love of money is the root of all evil. And that's what most of these things are. The reason why they're happening is because they're literally tapping in states and stealing heritages.
But the thing about what we have to understand about, like, what I love about what Keith is doing, right? He's taking us out of that world, right? And bringing us into another area, which this is where I talk about the choice of law as it relates to the conflict of law, because you got to certify the conflict. What is the law? So when you deal with your hereditaments, you already gave them instructions on how to deal with you. That is the choice of law in which I'm using the Quran. So if they're a Christian nation, they cannot use the Bible to now invoke certain powers against me because I'm in an Islamic jurisdiction. They don't have the right to do so.
Well,
Yep.
but now we're dealing with importing and exporting from
No,
the
we're talking
public.
about religion.
We
See,
are.
Congress shall lay and collect taxes. This means they're the ones that does all the licensing as well. And when it comes to the First Amendment, we have the law, the Congress shall make no law establishing or respecting the establishment of religion. This is why I say when you walk into a court, You can utter the Lord's Prayer or utter stuff from the Quran or the Torah, and it invokes the equity and tells them, hey, I'm not the same as you.
Right, I agree with that. However, there is a problem because of a lack of knowledge. You know, as it says, our people die from a lack of knowledge, and the heritage and all the, you know, if we're dealing on the public side, the assets have been placed in abeyance for them to administer and us instead of us ministering. And so there's different ways of going about of exporting it out of the public jurisdiction and importing it into the private. And what I appreciate is the two different approaches. The one that you're doing, Keith, because I'm also doing, but then I'm also wanting to play around on the other side, because the juridic person is a transmitting utility, right? That's what it was designed for, to transmit, you know. And unfortunately, it's been going the wrong way for the longest time, right? As far as the dielectric, it's been transmitting the currency in the wrong direction. So I'm hoping to flip the switch back.
But see, this is the problem, right? When you start dealing with that court process, they have so many doctrines. They have so many. It's so vast, and they can pull from all different types of stuff and make rulings. So they have what they call the strict scrutiny test, which they can use under strict scrutiny, under strict guidelines. Then they have the liberal construction test. They can liberally construe something.
That's
So now,
discretionary powers.
and that's what I'm saying. They can
Yeah,
use
well,
their,
you know, some people can come in and execute properly, that it has higher authority and jurisdiction with certain commands. You know, this is all
And that's the
hierarchical.
point he's making, though, is you better know what you're doing. Otherwise, they're going to do, like I said earlier, they're going to start grabbing at every creditor out there, going to look for every piece of information out there and try to use it against you with
use
their
it
plethora of codes and databases and
Yeah.
everything.
Mm-hmm. Yeah, I agree with you.
I don't want to play in that arena because I didn't won a lot of cases, and I started understanding how to. Once I understood how to win, I got to limit their possibilities of choices. I have to back them in a corner and have to force them to give me what I'm asking them to give me, because they never got the consent for them to for me to acquiesce and play on their playground. They cannot then subjugate my rights and utilize it because they're treating me in a certain capacity. No, I already had self-identified. This is the capacity that I want to want you to operate and for me and deal with me in this capacity. This is how you is to address me, and I already gave you everything you need. So now, like we took it out of probate, we're dealing with not civil rights, we're dealing with rights as it relates to inheritance, because that's what they're using.
Heritage.
They're saying, look, we as a Christian nation have the right to do all of these things. This is our inherent right. This is our right.
Yep.
It's
And
said
that's
in so many ways.
and that's basically what we're doing in this address thing. Remember, I told you it's right now everybody's using a name and address. We need to get out of that. And one of the ways of getting out of that is using a number in lieu of the name and address. But an even better way of getting out of that is like Prince, you use a symbol or mark in lieu of the number and the name. And so when we're talking about this, setting up a transitional credit, we're going to put the person in that account. And if anybody needs that person, they have to address me. That's where the address is now. Now they have to address me first and foremost before they can have anything to do with that person. No more of this reaching out and looking for information in the system. It's all going to be removed. That record is going to be expunged.
Exactly.
And now there is no address and they have to address me.
I mean, I ain't gonna lie, this is beautiful. This is beautiful. And I try to keep it simple. Because when you overcomplicate it, I'm telling you, these people working in concert they have multiple departments, multiple people that they're working with. You individuals, it's hard for an individual to deal with a machine. because they have unlimited resources. They have unlimited manpower that you don't have. You only can do so much within a 24-hour period. They have a whole room full of people that's
Yeah,
working.
well, I have a creator that is more powerful than all of them. Okay. So for me, I'm going to step up to whatever I'm called to do because I don't care what they're doing. I know that my creator is the creator of creation in life.
Amen.
And what most of and that's the reality. And like for me, I never straight up, I never ever imagined coming from my history that I would be called to such greatness to study right now with you guys. But I just need to put that right out there that whatever they're doing is nothing compared to the creator of truth.
Right.
And with that, I yield.
And that's what I like about you guys. You guys all have that same kind of attitude. Ain't nothing gonna hold us back. Ain't nothing gonna stop me. Nothing gonna slow me down. Nope.
Well, I was made wonderfully like this. A lot of people don't really appreciate it, and I'm not sure I do either. But the reality is like, hey, you know what? If I'm supposed to be a customs broker, my person, not me, because I'm acting in agency, then you know what? Cool. I'm going to let my person do that because I have another person that literally is more representative. It's like truly me, which is, I was known the original maritime jurisdiction, right? I was known before I was formed in the belly, brought forth from the womb, ordained and sanctified to speak unto the nations. Now, this heritage isn't even mine.
Yeah,
Like
exactly.
It's not mine.
Exactly.
I'm just supposed to look after it. And what are you doing with it? Errors and omissions. I made a mistake. Now let's correct the records, please. Whatever numbers you need, I'm going to collect them and give them back to you.
Yep. Yep.
So a lot of people don't, what you just said, the errors and omissions. So even with the birth record, most people don't correct their birth record. They'll leave it the same. So what I did is I attached my hereditament to my birth record, and then I just published it in the newspaper. Hey, blah blah blah. This is this and that, and this is where you can find the information.
Did it say blah 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 for real?
Not blah blah blah, but I just make this to make this try to keep it simple, and that's where a lot of people. So now it's not a probate issue. They don't have the jurisdiction to even deal with my rights of inheritance. I took it out of the probate court hands and created a document where now they have to deal with me according to my own jurisdiction. And then
Yep, which is private right. It's got to be done private, no longer public.
So now I am deemed the minister of family affairs. And that as a minister, I'm entrusted, right, and been appointed to handle the affairs of the estates. That's why I talk about the will and testament being the most important, because the will and testament, once it's been finalized, you can state your nationality, you can appoint the executor, you can identify your family, you can divide your symbols, your marks, your flag, whatever you want. And once it's finalized, nobody can add to it or take from it.
Did you enter that into probate by a notice?
I just put it, I'm not doing anything into probate. What I did was
let him know that he was removing everything from probate and did so by attaching his hereditaments to that birth document.
That's it. And then
well, did they hand you back your entire estate? Did you get your estate?
No, they ain't gave me nothing, but I'm not.
They don't have anything to give him. They don't have, that's the thing. They don't have anything to give him until he draws up that banker's acceptance.
Okay, because here we are, we're on to something, but we got to put all the steps together because like I have a couple of friends that did this and they got their genealogical records all the way back to freaking Egypt, and they got like all of their interest, all the knowledge about interest in mineral rights and oil, all that stuff.
Right. That's probably because they already had a piece of land and everything in their family and had some pretty good documents drawn up. Just putting a public notice out in the paper isn't going to accomplish that.